Or two, if you'll just let us know when you're ready.
Good morning, Your Honor.
Morning.
We got position number 4, Mr. Jesse Bray in front of you.
And let's see, I believe this is Mr. McLean's case. Is he on with us?
If he's not, Judge, I'm prepared. We can do 22 to the end of the calendar.
All right, good morning, Ms. Helen.
Good morning, Judge.
Would you mind letting Mr. McLean know the court has started?
Yes, Judge. I'll text him now.
Good morning, Your Honor.
Good morning, Ms. Tortorello. How are you today?
Good, how are you, sir?
Good.
So I guess we can jump to position number 22, Mr. Kawanish Marion.
Mr. Marion is 22 is represented by private counsel, Judge.
Is that you, Mr. Melnick?
No, Your Honor, I've got the email on the calendar, Chantrice Moore.
Yes.
See her in
I thought they were for you. No.
Yeah, Mr. Melnick is here for an add-on case for the add-on calendar. Mr. Marion has a private attorney. He's been reset from 9/27, I believe, so that his attorney can appear for him.
Do we know who that attorney is, Ms. Helen, by any chance?
I do not. I don't know if they made contact with the attorney last SAP court appearance or if that attorney got the link at that point, Judge.
All right. So apparently we can't do Mr. Marion right now, given that he doesn't have counsel. Ms. Helen's cases are 22 through 41 and add on 2.
And Judge, since I'm here, I don't actually see the South Annex on here right now.
Right, they don't normally join us until we're done in courtroom 2 quite often.
Okay, I'm gonna log off. I've got another calendar to join and then I'm gonna log back on it in just a little bit.
Okay, very good.
Thank
We'll see you later on.
Thank you.
You're welcome.
Your Honor, this is position number 23, Mr.
Okay. And that's a negotiated plea, Ms. Helen.
It is, Judge.
Good morning, Mr. McMillan. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Raise your right hand for me, please. Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Good morning, Ms. Bacchus.
Good morning, Your Honor. Good to see you.
Yes.
The state's offer on this case was 12 months, 32 days to serve, credit for time served 16 days, balance probated, SD course, and stay away from the incident location of Georgia State University at 95 Decatur Street.
And yes, Judge, that is the plea. We do accept it and we do stipulate to the factual basis, venue, and ID. It's a probated sentence. So, Judge, we are asking for those probated probation fees to be waived. And if the state is amenable, if it could be non-reporting once he completes that class.
There's no objection to that, Your Honor.
Understood, Judge.
Excuse me, Mr. McMillan. It's my understanding that in case 22 CR 006350J, you wish to plead guilty to simple assault and another misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
My question is, are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
I understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury.
Yes, sir.
Is anyone forced or coerced you to plead guilty?
No, sir.
I'm going to accept the plea as negotiated. I'm going to waive the probation fees while you're on probation to help you get and stay on your feet. And once you complete the terms, it'll go to a non-reporting status, okay?
Yes, sir. Thank you.
So the quicker you get it done, the quicker you won't have to report to probation. Good luck to you, sir.
Thank you, Your Honor.
Welcome.
Thanks, Judge.
Next, Your Honor, we have position 35 through 37, Antonio Stevens.
And so, yes, Your Honor, he has 3 positions, 35 through 37. Mr. Steffens.
So 35 is going to be a plea, and 36 and 37 will be arraignments.
Bond hearings, Judge.
Yes, well, arraignments and bond hearings.
Correct, Judge.
All right, so let me get the arraignments done first. Good morning, Mr. Stevens. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hands down. Thank you. Mr. Stevens, in case 22 CR 006396Y, you've been charged with battery family violence, and in case 22 CR 006397Y, you've been charged with battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Ms. Helen?
I do, Your Honor.
How do you plead to these charges, Mr. Stevens? Guilty or not guilty?
Not guilty.
Okay, we will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Let's see, in case, it's my understanding that you are pleading guilty in case 22 CR 006395Y to simple battery family violence. Ms. Bacchus?
Yes, Your Honor. One moment, my apologies. The offer on this case is 12 months, 26 days to serve, credit for time served, 13 days, balance suspended, no further contact with the victim, Antoinette Davis, and stay away from the incident location, which is 876 Hollywood Road.
Ms. Helen?
Yes, Judge, that is the basis of the plea. We do accept that plea. We do stipulate to the factual basis, venue, and ID. I just want to note that Miss Antoinette Davis is on the line. I don't know if she would have something or would like to speak, but I just wanted to make sure that you knew she was here in the courtroom or on the Zoom call.
Okay, thank you, Ms. Helen. Ms. Davis, good morning. If you would like to address the court in this matter prior to taking a plea, this is your opportunity to do so. You're not required to do so, but if you would like to say anything, that will be up to you. Ms. Davis, if you can hear me.
Yes, sir. Yes, sir, Your Honor. I would like to speak.
Okay, hold on. Raise your right hand for me.
Yes.
You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down, ma'am. Thank you. What would you like to tell the court?
We just have been going through it for like 4 years now. When it was my child was mistakenly injured at a house party that we had. And I have been going to my treatment. I have been getting my mental health treatment, been starting on my medication. I've been on my medication for at least 2 months now. And we're going back and forth to court to proceed with our kids. And they won't give us our kids until all the prior superior court is dismissed. And I do apologize, Your Honor, but it's just been so rocky and so shaky with this has been my first defect case. So I didn't know what to do. So I'm just listening to everybody, do this, do that, and then you can get your kids. And I still do this and that since this is my ever defect case ever. So it really was frustrating, and it really was just it was too much. It really was too much. And I honestly think that it's just like no one's after me, no one's trying to get me. It's just I was off my meds, and I will never be off my meds again, Your Honor. My husband is a good husband, good father to our kids on everything. He's our backbone. He's everything. And I just told him to make mistakes, Your Honor, by being off my meds. But you have one, I promise you will not worry about me being off my meds. Antonio he's been working for 4 years now in Austin Bulls, working on his own company. So I just do apologize. It's just been rocking.
Okay, thank you, Ms. Davis.
And Judge, I wanted to make sure that she was able to give her perception and feelings of this case because there is a current no contact and stay away. It sounds like Ms. Davis wants contact, or at least wants Mr. Steffens to be able to be in her and her children's life.
Well,
She
hold
is
on, hold on. The negotiated plea is no further contact. Not only do we have no further contact, but we have 2 additional cases that I have the bonds here in front of me where Ms. Davis is the alleged victim in these cases. Okay, so based on that, there's not going to be any further contact. So that was what was negotiated, and that's what we will go on. And even with these 2 bonds that are presently before me that we're going to discuss in a moment, there's to be no further contact. Okay, so
Yeah.
I appreciate that what you're telling me, Ms. Davis, but there's been some problems in this situation for a while. It's my understanding that today Mr. Stevens is going to take responsibility for at least one of these simple battery family violence charges. And as such, I will be going with the negotiated plea of counsel and the state. So, Ms. Davis, you have to understand that for the foreseeable future, there's not going to be any further contact between you and Mr. Stevens. If there is, if there is contact, and I understand that you've got some issues also, but just know.
Yes, we've been together 18 years. We've been married 18 years.
Okay, I
3 kids.
understand, but you're going through some things, it appears. So you're not going to have any further contact until these matters are resolved. Okay. No contact means absolutely no contact. And if you try to contact him, you're just putting him in a bad situation because he's going to be right back before us in jail right there. Okay.
Yes, sir.
Because he's gonna, either he is or he is not going to be out on bond on these other 2 charges. And if he violates those bonds, or if he violates this probation, the probation is going to be revoked, and he's going to be back in custody. So just know that, ma'am.
Yes, sir.
You'll be doing him no favors by trying to contact him while he's on probation. You understand me?
Yes, sir.
Okay, thank you, Mr.
Yes, Your Honor.
And I do appreciate that you're going through some things, but you're going to have to make sure that that the orders of the court, that they are upheld. Okay.
Yes, sir.
Thank you, Ms. Davis. Anything further, Ms. Bacchus or Ms. Helen, before we take the plea?
Nothing further, Your Honor.
No, Judge.
Okay. If you can unmute courtroom 2 for me, please. Mr. Stevens, it's my understanding that in case 22 CR 006395Y, that you wish to plead guilty to simple battery family violence. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'm going to accept your plea as negotiated. Mr. Stevens, the balance is suspended on this. So good luck to you, Mr. Stevens. Let's move on to positions 36 and 37. I have the bonds that were set by Judge Law back in September. They're both $5,000 cash bonds. Ms. Harrison, aside from these 3 charges, does he have any other history?
One moment, Judge.
Good morning.
Good morning.
Ms. Helen, while we're waiting, does he have any, do they have any children together?
They do, Judge. He has a total of 5 children. The youngest 3 he shares with Miss Davis, correct? 11-year-old, 9, and a 6-year-old.
Okay, so I'm not gonna keep him from his children, so he's gonna have a third party contact. So Ms. Davis, Mr. Stevens, I'm not gonna keep you from your children, but you're going to have to go through a third party to see your children, okay? So you're gonna have somebody arrange that.
Okay.
Okay,
Okay, Your Honor, I'm showing an open case in Fulton County for aggravated battery, 21 CP 197153. Additional open case, possession of firearm by convicted felon, 20 SC 174964. Additional open case for aggravated assault, strangulation, terroristic threats to the children, 2nd degree, possession of firearm during the commission of a felony, and possession of firearm by convicted felon, 21 SC 177970.
That's when that mistake happened in the home.
Ms. Davis, we don't talk over people in this court, okay?
No additional open cases, Judge.
Okay, based on that, Ms. Helen, the bond's gonna stay the same.
Understood, Judge.
Good luck to you, Mr. Stevens. Who do we have next?
Next, we have position number 39, Mr. Donnell Thomas.
Believe that's a negotiated plea, Judge.
Thank you.
I'm sorry, can you say that position number one more time?
39.
Thank you.
Good morning, Mr. Thomas. I'm Judge Eric Marr. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video? Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down, sir. Ms. Bacchus?
Yes, Your Honor, the offer on this case is 12 months, 30 days to serve, credit for time served 15 days, balance suspended, and stay away from the incident location, which is the Tuscany at Lindbergh Apartments at 600 Garson Drive, Northeast.
Ms. Helen?
Yes, Judge, that is our understanding of the plea. We do stipulate to the factual basis, venue, and ID.
Mr. Thomas, it's my understanding that in case 22 CR 006400C, you wish to plead guilty to loitering and prowling, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Thomas. You know you can't go back to that Tuscany on Lindbergh. You understand that?
Yes, sir.
All right, good luck to you, sir.
Thank you so much.
You're welcome.
Next, we have position number 26, Mr. Melvin Pugh.
It's also a negotiated plea. Good morning, Mr. Pugh. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Put your hand down, Mr. Pugh. Ms. Bacchus?
Yes, Your Honor. Just before I give the offer, I just wanted to, I didn't know if you wanted to dismiss Ms. Davis. She's still holding on, so I didn't know if she knew she could leave. The offer on this case is 12 months, 136 days to serve, credit for time served, 136 days, balance suspended, and stay away from the incident location, which is 2774 Donald Lee Hallowell Parkway Northwest.
Can I get that address one more time?
Sure, 2774 Donnelly Hollowell Parkway Northwest.
Yes, Judge, that is our understanding of the plea. We do stipulate to the factual basis, venue, and ID.
All right, Mr. Pugh, it's my understanding that in case 22 CR 002808J, you wish to plead guilty to loitering and prowling. Is that correct? Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with your counsel's representation? You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury? Has anyone forced or coerced you to plead guilty? Okay, Mr. Pugh, I'll accept the plea as negotiated. Good luck to you, sir.
Thank you, Judge. And for Mr. McLean, he's actually trying to log in now. He's just having some connectivity issues.
Okay, thank you, Ms. Helen.
That's all I have left in courtroom too, is Mr. McLean.
And if the host could check, I think Mr. McLean just texted me, he's waiting to be let in.
Not in there yet, Miss Helen. I've been watching. He's not in there yet.
Okay, thank you, Ms. Lewis.
Does he have the correct Zoom link?
He does. I believe I have a new October list for the SAP calendar. I just sent him. So.
And I just sent the link to Average Walker for position number 22. Miriam, just wait for him to log on.
Okay, thank you.
Good morning, Your Honor.
Good morning, Ms. Lynn. How are you today?
I'm doing well, Judge. How are you today?
Good. Which case are you here with?
Judge, I'm here on Brian Davis. He was in custody, but he's since been released. So I'm not sure if we need to be on this calendar or not. His position
Number 10, right? I have that he has been released. So he will be reset for another calendar.
Okay, that sounds great, Judge. We just wanted to be safer than sorry.
Good to see you. Have a good day. Thank you.
Good to see you as well. You do the same.
Good morning, Miss Lynn. How are you?
Good morning, ASG Walker. I hear the voice. I thought you were logged on. I wasn't sure. It's so good to hear you.
Good to see you as well.
All righty. You take care now. I'll be in touch with you.
Thank you.
Okay, bye-bye.
Mr. McLean is logging on now, sir.
Okay, thank you.
All right, whenever you're ready, Your Honor, we got position number 4, Mr. Bray again.
Okay, thank you. Good morning, Mr. McLean. Good of you to join us.
Good morning, Your Honor. Sorry to be so late. I apparently had the wrong number for joining.
All right. I'm sorry, courtroom 2. Tell me again what position?
Position number 4.
Number 4. Thank you. And this is a negotiated plea, Mr. McLean?
Mr. Bray states that it is. That is correct.
Okay, good morning, Mr. Bray. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me? The other one? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down, sir. Thank you. Ms. Torrella?
Yes, Your Honor. The state's, just to clarify for the record, the state's added 2 disorderly conduct charges for this case. So for count 1, disorderly conduct, 12 months served 17 days, credit for time served 17 days, balance probated, 12-week anger management. Count 2, disorderly conduct will merge with count 1. Count 3, criminal trespass is 12 months served 17 days, credit for time served 17 days, balance probated to stay away from the incident location, which is the Waffle House at 135 Andrew Young International Boulevard in Atlanta. and 20 hours of community service, and count 3 will run concurrent with count 1. Does opposing counsel stipulate to the facts, venue, and ID of the matter?
Yes, we do.
Nothing further, Your Honor.
Thank you, Ms. McLean.
Mr. Bray asked the court to accept the negotiated plea. We discussed it yesterday, and he asked to go forward.
Okay, Ms. Tortorella, any objection to termination when he completes the terms?
Hold on, Your Honor, let me look. No objection.
Thank you. Mr. Bray, it's my understanding in case 22 CR 006318C, you wish to plead guilty to criminal trespass and disorderly conduct. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're given the right to a trial by jury? You don't want a jury trial, do you?
No.
Has anybody forced you or coerced you to plead guilty?
No.
I will accept the plea as negotiated, Mr. Bray. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And as soon as you complete the community service and the anger management, then the probation is going to terminate, okay?
Okay, excuse me, can I please, when I leave court, can I please have paperwork of what happened in court today, please?
Okay, Mr. McLean, would you mind getting Mr. Bray the paperwork? So we'll have that for his records.
Yes, Your Honor, I'll do that. I'll first come over to or send the paperwork to the court, and then I plan to head to the jail afterwards.
Okay, very good. So you'll get the paperwork, Mr. Bray, okay?
So this means I get released today?
As soon, if you don't have anything else holding you, as soon as the jail can process you out.
Okay, thank you, sir.
Okay, you have a good day, Mr. Bray.
Next, we have position number 9, Mr. David Craig.
And that's a negotiated plea as well.
Good morning, Mr. Craig. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Good morning, yes.
Good morning, sir. Let's see, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you. Whose case is this?
Your Honor, it was negotiated by Ms. Hogue and Ms. Harmon for the state, and they turned in the paperwork, and I'm here physically to preside over it.
Okay, good morning, Ms. Harmon. I saw Ms. Harmon there. I saw Ms. Tortorella there, so I wasn't sure who was going to present this morning.
Good morning, Your Honor. Yes, Your Honor, in this case, for Mr. Craig's case, the state is recommending for the first charge, time served 78 days. And for the second charge of disorderly conduct, a null pros on that case. Does the defense stipulate to the factual basis, venue, and ID for purposes of the plea?
We do so stipulate.
I'm sorry, tell me what the negotiated for the first charge is.
It's a time served 78 days.
Okay, so I've got down balance. So is balance suspended?
Yes, Your Honor. It's just.
Okay, all right, just wanted to make sure.
Okay.
Not really a balance technically, because it's just time served period.
Right, okay. Anything further, Mr. McLean?
Nothing.
All right, Mr. Craig, it's my understanding that in case 20 CR 005287E, you wish to plead guilty to one misdemeanor offense, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Craig. Good luck to you, sir.
Thank you, Your Honor.
We got nothing all plus, Ms. Champion?
No, sir, they need to send the null pros to me.
Okay, Ms. Champion's in court with me today, so if you can get her that null pros, we'll get it signed.
Absolutely. And Your Honor, which courtroom are you in?
G33.
Okay, I'll walk it down.
Okay, thank you.
Good morning, Your Honor.
Good morning.
I apologize for interrupting,
Hey,
Your Honor,
Mr. Walker, your client is next. I already got you.
okay, all right.
Petition number 22, Your Honor.
Okay, thank you. And Mr. Walker, what are we going to do with Mr. Marion today?
Judge, I was on trial. I was on a murder trial yesterday. So last night we played out. So I'm here this morning. At this time, Judge, we filed an interim appearance this morning. We plead not guilty and we demanded a trial by jury. So we know that Judge Wesley Taylor will be the judge. So we filed an entry, and in our entry, we waive formal arraignment, plead not guilty, and demand a trial by jury, Your Honor.
Okay, so I think that if you'll get that, if you've already filed a waiver in the case, then we will send this back to the division judge, and you'll get notification of your next hearing date.
Thank you, Judge. It's good to see you.
You also have a good day. Mr. Marion, you also.
Which position was this, Your Honor?
Position 22.
Okay, thank you.
Thank you.
All right. Who do we have next?
Next, Your Honor, we have position number 16, Mr. Goodwin.
So this is going to be an arraignment and a bond hearing, is that right? Mr. Fine.
I mean, yes, Your Honor, that's a bond request. They're not guilty.
Okay. Good morning, Mr. Goodwin. I'm Judge Eric Morrow. This is the state. Good morning, sir. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
You raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Nothing but, sir.
Okay. You can put your hand. Thank you, Mr. Goodwin. Let's see. You have been charged in case 22 CR 006311Y with battery, disorderly conduct, and public drunk. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McCain?
We do.
How do you plead to these charges, Mr. Goodwin? Guilty or not guilty?
Not guilty.
You record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Let's see. On September 19th, a bond was given as a total of a $2,000 good bond. Is there a history, Ms. Harrison?
3 cycles, last arrest November of 2019 for terroristic threats and act in Fulton County. That charge was dismissed. Nothing further to add.
Okay. Ms. Tortorella?
Yes, Your Honor. This defendant actually has 2 cycles out of Michigan and 3 cycles out of Georgia, so he's a multi-state offender. This defendant does pose a danger and threat to the person of Jamie Treep and any person in the county of Fulton. This incident occurred on September 18th, 2022 at the Atlanta Medical Center, 340 Boulevard Northeast in Atlanta. Officer M. Diaz of the Atlanta Police Department was dispatched to a person injured at the incident location. Upon arrival, the officer spoke to the hospital security guard, Stephen Strickland, who stated a white female came into the emergency entrance of the incident location, injured with blood on her face and body. Mr. Strickland stated that the white female, later identified as the victim, Jamie Tripp, advised she was assaulted by a black male right outside the hospital. Mr. Strickland showed the officer video footage, which showed the black male, later identified as the defendant, Dion Goodwin, enter the emergency entrance of the hospital. Mr. Strickland stated that when the suspect entered the hospital to antagonize Miss Tripp, and he did so after he had already assaulted her, the suspect admitted to beating up the victim. Miss Tripp was being treated by the hospital in one of the emergency rooms, and she stated she was punched and kicked by the defendant multiple times on her mouth, right arm, and back. The officer noticed the victim had a bruised lip, rash marks on her right arm and back. Miss Tripp stated that she was walking outside the hospital when a black male approached her and began to beat her up for no reason. The defendant was located and immediately detained. Defendant appeared to be under the influence of alcohol and was using profane, loud, and unbecoming language towards the officer and others at the incident location. Mr. Goodwin was being disorderly throughout the whole custodial process as well. All these events did occur in Fulton County, Georgia. Your Honor, we are concerned that this defendant will intimidate the victim and others. It's foreseeable due to the facts of this matter. It's important to point out, Your Honor, that after the defendant beat the victim, he followed her inside the hospital to continue to antagonize her. To add, we also have grave concerns for the safety of the citizens of Fulton County, as this incident was random and unprovoked by the victim. So therefore, Your Honor, this $2,000 surety bond is more than reasonable. It's a very low bond for what occurred here. Nothing further.
Thank you, Ms. Tortorella. Mr. McLean?
Your Honor, the defendant does deny the charges. He has jobs waiting on him. He is a landscaping crew leader for one organization and also has another organization that does similar work. Considering the history and his denial, he asked for a signature bond. He has no problem with staying away from the area, but keeping him in jail to keep him away from everybody in Georgia, he feels is extreme.
Yeah.
Okay, so, Mr. McLean, you're gonna have to take this down.
Yes, sir.
It's gonna be a $5,000 SOB through the jail for the battery. $1,000 SOB through the jail for the disorderly. $1,000 SOB through the jail for public drunk.
5, 1, and 1 through the jail.
Right, no further contact with Jamie Tripp. And no drugs, alcohol, weapons while out on bond. And stay away from Atlanta Medical Center unless seeking treatment.
I'll write that up.
Okay, and Atlanta Medical Center is at 340 Boulevard. All right, I'm gonna let you out, Mr. Goodwin, but if you violate the terms of this bond, or if you don't appear for your next hearing date, then you're gonna be right back where you are, okay?
No problem, but sir, I have to have more surgeries on my eye. I can't see you at the side.
Okay, I'm sorry to hear that, Mr. Goodwin. I hope you feel better.
Yes, sir.
Okay, good luck to you, sir. What do we have next?
Let me give position number 19, Mr. Jackson.
This is a negotiated plea.
Yes.
Your Honor, my lieutenant has an announcement.
Okay, Donna.
Good morning, everybody. Just want to let you know that there's no internet service at Union City, so the females on the calendar can't appear.
Okay, do we have a list of those that we're gonna need to reset? Or,
I never received a list. I do apologize. I just know from my staff working over there informed me to let you guys know.
all right, so I guess that's gonna go for this afternoon also for the SCA calendar?
Yes.
Okay, all right.
But they are getting the ladies interviewed. That's over the telephone.
Okay,
And then if their appearances can be waived, then their cases can move forward.
okay, very good. Thank you.
Your Honor, in the first half of the calendar, that would be position number 2. That is the only Union City inmate on the first half of the calendar.
Judge, and I have position 25 as a reset. Again, she had a time served offer, but she'll be a reset. As well as position I believe that's, oh, and position 40, Ms. Westbrook's.
Okay, and I think that there's a private attorney that has someone at Union City also. I can't remember which position that was. Okay, so all of those, do you want to have, I mean, times, if your time served, please, you want to have them reset for Thursday?
Yes, Judge, if that could be possible, if that's possible to put them on for Thursday, because I do have two who have time served offers.
Okay.
Your Honor,
Yes, Ms. Harmon.
yes, Your Honor, I think that's Ms. Moore's case. That would be the private attorney with Mr. Melnick. Is she in Union City? She's on the add-on calendar.
Okay, right.
And that is a time served offer as well.
And Thursday's fine for number 2 as well.
Okay. So do we
I'm
know,
sorry. Go ahead, Your Honor.
do we know who's represented? I've got 31 and 32 have a private attorney. Do we know who that is?
I think 31 through 33 they're all the same position, and I do not have the attorney's name.
That's correct, Judge. That'll be Mr. Sheets. He did not have the attorney's name, but he assured me he had already paid and retained attorney who's going to appear for him today.
Okay, so he's gonna be here. Okay. All right, so 2, 25, and 40, those are all gonna be reset for Thursday, 10/6.
Yes, sir.
Okay. All right, so who do we have now in courtroom 2?
And position 40, Judge, Ms.
Yeah,
Westbrook.
right. 2, 25, and 40, right?
Yes, sir.
Okay.
This is position number 19, Mr. Jackson, position 19.
Good morning, Your Honor. Can I please make a statement?
Hold on, Mr. Jackson.
Yes, sir.
Mr. Jackson, let's see. You have a right to remain silent. Anything you say can be used against you. You have counsel here representing you, Mr. McLean. I would suggest if you want to speak with Mr. McLean, I'm happy to let you do that so that he can either answer whatever questions that you might have, or that he can present them to me if he thinks that they're appropriate. Do you need to talk to Mr. McLean before we go forward?
Yes, sir.
Okay, Mr. McLean, did you hear that?
Yes, sir. I just made some noise, sir.
Oh, hold on, Mr. Jackson. This is being recorded and it's live on YouTube. So I don't want you to say anything that's going to get you in any trouble. Okay.
Yes, sir, Your Honor.
All right. So I'm going to let you speak with Mr. McLean if that's what you want to do, so that he can address your concerns before we go forward. Did you hear that, Mr. McLean?
Yes, Your Honor.
Okay. So how can we achieve that? Can you call him?
Yes, sir, Your Honor. I'm just begging for a second chance, Your Honor, because I really have a future ahead of me, sir. And I don't want to sit boxed in all day, you know what I'm saying, flying emotions, because I really want to prolong my life, sir. I'm just praying for you. I'm just praying for a second chance, sir, that you please dismiss my case, sir. In Jesus' name I pray, amen.
Okay.
Either a breakout room or a phone call to extension 2-5215 would work.
What's the easiest way to do this, courtroom 2?
You can call in courtroom 2. Go ahead, yeah, switch seats for me. Yeah, you can have a seat over there. You can call to 2392.
And Your Honor, the state's in communication with the victim. She may log on.
Okay.
Hang up.
And Mr. McLean, just so you know, I think that all the other cases that are in courtroom 2 are your cases. So
Yes, Your Honor.
we'll be on recess until you come back.
Next, we got position number 5, Mr. Calhoun.
Okay, so Mr. McLean's gonna be on the phone with
Okay.
Mr. Jackson, so I don't think we can move forward until he gets back with us. Because didn't you tell me earlier, Norris, that all the rest were Mr. McLean's cases?
That is correct. You're right, Your Honor.
Thank you.
Okay. McLean, you have the number? You're muted, McLean. You're muted.
Okay, can you
404.
dial? Okay, I can dial you, yes.
Yeah, 404-612-2392.
Okay, thanks.
Thank you.
This champion.
Yes, sir. Well, that's what.
Courtroom 2, is Mr. Sheets positions 32 and 33, 31, 32, 33 there with you?
No, he's upstairs, Your Honor.
Okay.
I'm gonna see if I can see where the rover's at. Hold on. I get it.
All right, thank you.
All right.
Your Honor, I believe we're ready.
All right, is this still going to be a negotiated plea,
Mr. Jackson states that it is.
All right. So if we can unmute. Thank you. Mr. Jackson, can you raise your right hand for me?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Okay, thank you. You can put your hand down. Thank you. Ms. Tortorella?
Yes, Your Honor. For the charge is 12 months, served 90 days, credit for time served 25 days, balance probated, 40 hours of community service, SDET, no contact with the victim. Her name is Sequoia Huff. First name is SEQUOIA, last name is HUFF. To stay away from the 5 Points MARTA station at 30 Alabama Street in Atlanta. And does the defense stipulate to the facts, venue, and ID of the matter?
Your Honor, on And Mr. Darrell, on the negotiated plea, my understanding was it was going to go directly into the class. It's far less expensive, and he will be seeking to get it through public health, probably Grady, the sexual deviancy class.
You're correct. You're correct. Sexual deviance class.
Because that evaluation costs $1,500 and he doesn't have it. But yes, let's do that. And I believe he understands each element of the negotiated plea and he asked the court to accept that.
All right. Mr. Jackson, it's my understanding that you wish to plead guilty to this misdemeanor offense. Is that correct? Okay, you're on courtroom 2, you're on mute. You wish to plead guilty to this misdemeanor offense, Mr. Jackson?
Yes, sir, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, Your Honor.
You understand that you have a right to a trial by jury and that by pleading guilty, you're giving up your right to a trial by jury?
Yes, sir, Your Honor.
Has anybody forced you to plead guilty?
No, sir, Your Honor.
All right, I'll accept the plea as negotiated, Mr. Jackson. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire time, okay? But I'll help you out with the fees, okay?
Sure, Your Honor.
All right, good luck to you, Mr. Jackson.
Does this mean I'll go to this?
Your Honor, I believe the victim is on Miss Huff. Not sure if she wanted to speak.
Okay. Ms. Huff, if you'd like to address the court, you're not required to. Now is your opportunity to do so. We've already taken the plea in this case, but if you would like to address the court, you'll have to unmute yourself, activate your camera, and I'll have to swear you in. All right, thank you, Ms. Tortorella. It does not appear that she would. Who do we have next?
Judge, I apologize. I don't want to interrupt you. Mr. Steffens would like to be called again for positions 37 and 36. He would like to accept the offer from the state. I only have an update as far as the jail time. So I guess it's a non-negotiated plea at this point.
Okay, so you're gonna have to. So why don't we do this? There's more jail time in regards to this. Why don't we just put him on next Tuesday's calendar? So that gives you time to get the paperwork done. And it's not as though he's, you know, if he's gonna plead to it, then he's gonna have to do additional jail time. So can we just put those two on next Tuesday's calendar?
Yes, Judge, October the 11th should work.
So 37 and 36, October 11th, reset.
Correct, Judge.
All right, thank you, Ms. Helen.
You heard it. Thank you. Jackson, he's gonna explain it to you. I need to get out the courtroom. We got position number 5, Your Honor, Mr. Calhoun, position number 5.
Okay. And this is going to be a non-negotiated plea.
That is correct.
Good morning, Mr. Calhoun. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Let's see, Ms. Harrison, can I get his history, please?
Your Honor, sorry to interrupt, but yes. I have the other officer on 4 North and they're waiting in the waiting room to be let in.
Okay.
Let in for a few minutes, and that's where Sheets and everyone else is at.
Unfortunately, they're not in my waiting room. They must got the wrong link because I've been sitting here.
Okay, I'll let her know. Thank you.
Okay, Ms. Harrison.
Yes, Judge. I'm showing 1 moment. 6 cycles. Last arrest was September of 2018. Failure to appear. Underlying charge was entering auto. Record indicates an open case. 18 SC 161698, theft by receiving stolen property, possession of MDMA with intent to distribute, possession of controlled substance in Schedule 1 and 2, possession of Schedule 4 controlled substance, possession of firearm or knife during the commission of a felony, and obstruction of law enforcement officer. He has a 2019 first offenders. Entering auto, 3 counts. It's not indicated was sealed. Nothing further to add.
So aside from the first offender in 2019, are there any other convictions?
I am not showing any others.
Okay, thank you. Ms. Tortorella?
Yes, Your Honor, I just want to know what's at issue before I proceed.
It's an unnegotiated plea because he would like to ask the court to consider time served, essentially time served, or if the court is not comfortable with that, a minimal extra jail days sentence that would calculate out with the math that we usually do, the 2-for-1 good behavior credit, to constitute no more than, say, 30, 45, or 60 extra jail days. That's the range he'd like to consider. And he would also like to put forth the notion that to show his good faith, the fine could go from 0. There is no fine proposed at this time by the state. The fine could go from 0 to $1,000. He will work on that. He would like to ask for more community service if necessary to prove his good faith. And I believe I believe it's 12 weeks of anger management is at max anyway, so he can't ask the court to consider increasing that. But he'd like to say, let me do more work on this. And I would like to emphasize another main point, which is this was 5.5 years ago.
Okay, so Your Honor, the state's asking for count 2, the battery, 12 months to serve, 365 days, credit for time served, 32 days. For count 1, the criminal trespass, 12 months of probation, no contact with the victim, Kelsey Small. Her first name is Shekelcy, 80 hours of community service, and that will be consecutive to count 2. Count 3, marijuana less than an ounce will be no prost. Count 4, reckless conduct will be 12 months of probation, no contact with the victims, Ms. Small, and the juveniles involved, SB and CP, 12 weeks of anger management, and that will be concurrent with count 1. Your Honor, the reason for the jail time is number 1, just the nature of what happened here. This actually should have been an aggravated assault. This incident occurred on May 5th, 2017 at 5081 Upper Elm Street in Atlanta. Officer Jay Parks of the Fulton County Police Department was dispatched to the incident location in reference to a physical altercation. Upon arrival, the officer made contact with the victim, Ms. Small, who advised she had just been assaulted by her cousin, Casey Calhoun. Ms. Small said the 2 juveniles, SB and CP, were hungry and decided to get something to eat. As Ms. Small was getting inside the vehicle with the 2 juveniles, the defendant advised that he wanted to stop and get some cigarillos somewhere. Ms. Small told defendant they were not making a stop to get the cigarettes. The defendant became angry, got out of the vehicle, and came to the driver's side window and began punching the window while yelling and cursing at Ms. Small, who was inside and sitting on the driver's seat. The defendant was punching the window while she was inside. Your Honor, I can't continue. There's loud noise behind. Okay, Ms. Small got out of her vehicle to confront the defendant about the issue, but the defendant turned around and picked up a brick from the grass. The defendant began to approach Ms. Small while he was holding the brick in his hand. Ms. Small quickly went back inside her vehicle with the two juveniles inside the car because she did not know what the defendant was going to do with the brick. The defendant threw the brick through the driver's side window and busted the entire window out. The defendant then reached in the vehicle and punched Ms. Small on the left side of her face. Ms. Small sustained lacerations to her face, hands, and feet due to the window busting within close range of her. And the defendant was eventually arrested, and these events occurred in Fulton County, Georgia. To add, Your Honor, he was given a bond by a judge for this case by a Judge Frazier, which the original bond order granted by this judge imposed no violations of laws and ordinances of the state and no weapons. And his subsequent felony case, Your Honor, includes a violation of Georgia laws, which he's on a judicial hold status for. And to add, he was caught with a possession of firearm or knife during a commission of felony. So therefore, Your Honor, the state does feel that the offer is more than reasonable for what occurred here and what the defendant's criminal history. Nothing further.
Okay, Mr. McLean.
Your Honor, we understand the state's argument. I would only add that in his request to consider increasing the community service, it's currently at 80, I believe, and he was thinking, he could do 200 or 300 hours. He's quite, he is remorseful that this occurred. He says the window broke due to his actual punching on a hand as opposed to a brick. He denies the brick. And so he says it's not quite what it seems in the police report. And he points out too that the 18 SC case, I believe that is open, so he would be presumed innocent, and he hopes to prevail on that.
And let's see, the reason that the state is not recommending FVIP is because of the 365 days that you're requesting. Is that right?
Well, they're just, oh, I'm sorry, you're asking to say, so I apologize.
Yeah, Your Honor, this is not a family violence case. That there's no indication that they actually resided together. This is just a family matter that involved a battery.
How is the victim, does the victim know Mr. Calhoun?
They're cousins.
Cousins.
The state is correct.
And let's see, right now, the state for the criminal trespass, you're asking for 80 hours of community service, is that right?
Yes, Your Honor.
Okay. And for the reckless, you're asking for 12 weeks of anger management.
That's correct, Your Honor. And that runs concurrent with the count one.
But you want count one, but you want count one to run consecutive to count two?
No, so count two is the battery charge. So count two will be the 12 months to serve 365. Then count one is the criminal trespass, and that will run consecutive to count two. And then counts 1 and 4 will run concurrent.
So you want him to be on probation for 2 years?
Correct.
And why is that?
Given the nature of what happened here, Your Honor, and the fact that he's still on a hold for his felony case. I think
I mean, he only has one conviction. So
Your Honor, the state feels like the brick was thrown through a window. It could have been worse, Your Honor.
And Mr. McLean, what is your argument about more community service?
He was saying, please let me show good faith by doing more community service. Instead of doing 80, let me do 200, let me do 300. The 12 weeks of anger management is 12 is usually the max on that anyway. And on the fine, there is no fine proposed at this point, but he's saying, I can pay a fine, I can work. He does deny the brick. He did point out to me that the juveniles were teenagers at the time and they're adults now.
Okay, so just for your consideration, Mr. McLean, I am going to make him do more than 60 days. And I think that you had requested 30, 45, or 60. But
correct.
It's going to be more than 60. So
I did discuss with him that an unnegotiated plea carries the risk of going outside the boundaries of what we're talking about.
and for the reckless, there is a no further contact requested. Is that right or not?
Correct. That's the reckless is no further contact with the Miss Small and the juveniles. The reckless was there because of the juvenile victims, Your Honor. They were inside the vehicle when the brick was thrown.
All right, anything further before we move forward with the plea?
Nothing further from the state.
Yeah, I'm trying to read the body language of my client, Your Honor. Do you need to talk to me about exactly what's going on before we go forward, sir? Or are you okay with listening to the court pronounce sentence?
Yeah.
I don't know if he heard me.
Can you repeat it?
Are you ready to go forward, Mr. Calhoun?
I said, can you repeat it?
The court is about to announce its decision, Mr. Calhoun. Are you ready?
Yes,
are you okay?
All right, Mr. Calhoun, it's my understanding in case 17 CR 020008Y, you wish to plead guilty to battery, criminal trespass, and reckless conduct. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
All right, the sentence is going to be for the battery, 12 months to serve 90 days, credit for time served 32 days, balance probated, 12 weeks of anger management, no drugs, alcohol, or weapons while on probation. For count for the criminal trespass charge, the sentence will be 12 months to serve 90 days, credit for time served 32 days, balance probated. with 150 hours of community service. For the reckless conduct charge, 12 months to serve, 90 days, credit for time served, 32 days, balance probated, no further contact with Ms. Smalls and Mr. Bridges and Ms. Pierce. And all of these are to run concurrent. You're going to be on probation for the entire 12 months. As such, I'm going to waive the probation fees for you to help you get and stay on your feet. Consideration was taken as to this case happening back in 2017 and Mr. Calhoun only having one conviction on his record. Good luck to you, Mr. Calhoun.
Can I say one thing?
You have a right to remain silent, Mr. Calhoun. Anything you say can be used against you. So I would suggest that you speak with Mr. McLean later if you have a question.
I concur with that, Mr. Calhoun.
And Your Honor, just to clarify, the state will be no processing the marijuana less than an ounce. That was part of the.
Yes, that was my understanding. Thank you, Ms. Tortorella.
Yeah.
And if you will get that null process onto Ms. Champion, we'll get it signed.
Are you waiving any fees, Your Honor?
Yes. All right. Good luck to you, Mr. Calhoun. Who do we have next?
Position 1, 4 North.
Also, Judge, Attorney Muhammad is on the Zoom call for position 31, 32, 33.
So let's see. Is this position 1? Is that position 1 on the regular calendar or on the add-on calendar?
Position 1, regular calendar.
Okay. And this is negotiated plea, Mr.
Yes, yes, it is.
Let's see, good morning, Mr. Allen. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Is that a yes?
Yes, sir.
Okay, you can put your hand down, Mr. Allen. Ms. Tortorella?
Yes, Your Honor, for the first count of theft by taking is 12 months served 30 days, credit for time served 15 days, balance probated, to stay away from the incident location, which is the Super Rica at 1130 Avalon Boulevard in Alpharetta. Balance probated in a theft class. For count 2, theft by taking, same 12 months served 30 days, credit for time served 15 days, balance probated, stay away from the incident location, and it will run concurrent to count 1. Does the opposing counsel stipulate to the facts, venue, and ID of the matter?
We do so stipulate.
Nothing further.
Any objections or termination after you completes the theft class?
Let me check, Your Honor. He has several open cases. He has an open felony case, 2 open felony cases, Your Honor, so the state will object.
Mr. McLean?
Your Honor, he is a graduate of Douglas High School. He's about 18 years old. And with the job market being what it is, considerations on finances are great, would be great. And he asked the court to accept a negotiated plea. He will take that theft class and he will stay away from those places.
Okay.
Or that place.
Mr. Allen, it's my understanding that in case 22 CR 0061171Y, you wish to plead guilty to 2 counts of theft by taking. Is that correct?
Yes, sir.
You under the influence of any drugs or alcohol this morning? Say, answer verbally for me.
No, sir. I just woke up.
Okay. You've been represented by counsel. You're satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
What do you mean by that, sir?
Nobody's forced you to enter a guilty plea, have they? Okay. I'll accept the plea as negotiated. Mr. Allen. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the theft class, it'll go to a non-reporting status, okay? All right, good luck to you, Mr. Allen.
Thank you.
You're welcome. Who do we have next?
Position number 8 on the regular calendar.
Okay. And this is going to be an arraignment, is that right?
I believe that is correct, yes.
Good morning, Mr. Cox. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you. You've been charged in case 22 CR 006391A with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do waive that, yes.
How do you plead, Mr. Cox? Guilty or not guilty?
Not guilty.
You'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Yes, sir.
Who do we have next?
Judge, give me a moment. I have to go to 3 South and I log on downstairs.
Okay, thank you. Courtroom 2.
We got position number 6, Mr. Carnicki.
This is a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Carnecki. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you, sir. Ms. Tortorella.
Yes, Your Honor. For count 1, loitering and prowling, 12 months, serve 11 days. Credit for time served, 11 days. Balance probated to stay away from the incident location at 523 Joseph E. Boone Boulevard in Atlanta, and an anti-theft class. For count 2, criminal trespass, 12 months, serve 11 days. Credit for time served, 11 days. Balance probated to stay away from the incident location, 523 Joseph E. Boone Boulevard. 50 hours of community service, and count 2 will run concurrent to count 1. Does opposing counsel stipulate to the facts, venue, and ID of the matter?
We do so stipulate, yes.
Nothing further, Your Honor.
Any objection or termination when he completes the terms?
Let me double check, Your Honor. He currently has a hold, Your Honor, and he's being held on a bench warrant for failing to report. So, Your Honor, we are objecting. We will object.
Mr. McLean.
Your Honor, he does. We talked over the facts of the case. While this is essentially an offered plea. He feels he was not there to steal anything, but he was at the location, and he realized he didn't have the right to be there at that time. And so he's just asking the court to accept the negotiated plea. Finances being what they are in this economy, he would ask for any consideration the court give him there on probation fees. He's certainly willing to do the class and the community service, and he will stay away.
All right. Is it an offered plea or is it a guilty plea?
Well, it's basically an offered motivation for a guilty plea. Yes.
I don't know what basically offer.
I agree with you. I agree with you, Mr. Walker. I'll get there.
But either way, the state is objecting, Your Honor. I'm sorry.
You're objecting to the offered plea.
Yes, Your Honor.
Yeah, you don't have to be sorry, Mr. Walker. You're fine. So, Mr. McClay, it's my understanding this is a guilty plea. It's either going to be a guilty plea or you're requesting an offer.
Right.
So,
Well, as I discussed with him, while he did discuss it with me, he made a decision to ask for the negotiated plea that the state offered.
So it's a guilty plea.
It's a guilty plea.
Okay. All right, let's see. Mr. Carnecki, it's my understanding in case 22 CR 005739D, you wish to plead guilty to loitering and prowling and criminal trespass. Is that correct? Yeah, you're on mute, courtroom two.
Yes, sir.
Hold on for me just 1 second. Is that?
Hey, Dixon.
Right, I apologize. Let me start from the top. Mr. Karnicki, it's my understanding that in case 22 CR 005739D, you wish to plead guilty to loitering and prowling and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Does anyone force or coerce you to plead guilty?
What'd you say?
Anybody forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Karnicki, I am going to waive the probation fees while you're on probation to help you get and stay on your feet. And when you complete the anti-theft class and the 50 hours of community service, the probation is going to terminate, okay? So the sooner you get that done, the sooner you won't be on probation, all right?
Yes, sir.
All right, good luck to you, Mr. Karnicki.
Next, we have position number 12, Mr. Darren Dixon. Darren Dixon.
Good morning, Mr. Dixon. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Sure.
Thank you. Can you raise your right hand for me, Mr. Dixon? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
No.
Okay, you can put your hand down. Thank you. Ms. Tortorella?
Yes, Your Honor. For count one, battery, family violence, 12 months, served 16 days, credit for time served, 16 days, balance probated, no contact with the victim, Maya Woodall. First name is M-Y-A-H, last name is W-O-O-D as in dog, A-L as in log, L as in log. To stay away from the incident location at Budgetel Inn and Suites, 4120 Fulton Industrial Boulevard in Atlanta, and Family Violence Intervention Program course. For count two, cruelty to children in third degree, the state will move forward and dismiss that charge as part of the plea offer. Does the opposing counsel stipulate to the facts, venue, and ID of the matter?
We do so stipulate, yes.
Nothing further, Your Honor.
Let's see, Mr. McLean.
Your Honor, he's now a single dad. He states to me that Ms. Woodall is not to be found and is not involved in the child's life. And so financially, as a single dad now, he needs breaks if the court can afford it could afford him a break on finances. The FVIP, I told him, would be rather expensive. He is an Amazon driver of one of those tall vans, and he is working full time and trying to keep things together for the family, the two-person family.
Okay. Mr. Dixon, it's my understanding that in case 19 CR 004682Y, you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Is anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Dixon. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you finish the FVIP class, it'll go to a non-reporting status, okay?
Yes, sir.
Good luck to you, sir.
Well, one more thing, like, can I have some paperwork, please?
Yes, Mr. McLean will provide you with paperwork after court today, okay?
All right, thanks.
Certainly.
Have a good one. We have position number 21, Mr. Mario Lewis.
Good morning, Mr. Lewis. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
And can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, sir. Ms. Tortorella?
Yes, Your Honor, for count one, theft by taking is 12 months served, 17 days, credit for time served, 17 days, balance prorated. To stay away from the incident location at 845 Peachtree Street in Atlanta and an anti-theft class. For count three, obstruction, 12 months served, 17 days, credit for time served, 17 days, balance prorated, $300 fine, 40 hours of community service. And count three will run concurrent to count one. And as part of the plea offer, the state will null pros counts 2 and 4. Does opposing counsel stipulate to the facts, venue, and ID of the matter?
We do so stipulate, yes.
Nothing further, Your Honor.
Any objection to termination?
No objection.
Mr. Payne?
Your Honor, he will stay away from that location. He will take the class, he tells me. He understands. I talked to him about the statute and the obstruction and the 300 fine, and he will certainly do the 40 hours community service. He asked the court to accept the negotiation so he can get on with rectifying this. He's 42 years old approximately, and he does ask the court for some consideration on the finances.
Okay. Mr. Lewis, it's my understanding that in case 22 CR 006314B, you wish to plead guilty to theft by taking and willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you've given up your right to a trial by jury?
You understand? Give me. I don't want to try.
Don't want a jury trial, do you?
No, sir.
Has anyone forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Lewis. I am going to waive the probation fees for you while you're on probation and help you get to stay on your feet. And when you complete the terms of the probation will terminate. So the sooner you get all this done, the sooner you won't be on probation, all right?
Can I just have an instruction on how to get to the class or whatever?
Yes, you will. They'll give you that information at probation, all right?
All right.
All right, good luck to you, sir.
All right.
Who do we have next?
Position number 15, Mr. Freeman.
What are we doing with position 15, Mr. McLean?
Let's see, 15 is he was asking to have a global offer. He says he's got another misdemeanor. I told him that it was unlikely that we'd be able to really get paperwork on the other case number by this morning. So as a practical matter, since that other case is hanging him up as well, we might need to put this off a couple of days if the state doesn't have a global offer right now.
And just to be open with the court, we are working on getting the case accused. It hasn't been accused yet, but he has a bond on that simple assault charge for $5,000 surety bond. So
Mr. McLean, do you want to put this off until next Tuesday? I don't know.
That would be fine.
Okay, we'll reset Mr. Freeman until next Tuesday to see if we can handle it all at one time.
Do you understand, Mr. Freeman? Is that what you understood?
Yeah, I'm good with it.
Okay.
Yes, sir.
All right, thank you. Let's do 11. Who do we have next?
Your Honor, we should go to medical. I believe she was a medical.
Okay, I saw them on just a moment ago, but
I don't know what happened.
Right, I don't see.
But I do have one quick announcement.
Okay.
Mr. Michael Roberts is going to be a medical reset. That's position, I'm sorry. Position 28.
8, okay.
For position 28, did he say medical reset?
That's correct.
Okay, thank you.
You're welcome.
Let's see, Ms. Helen, do you want to, I mean, it's a time served. Do you want to put this on Thursday?
No, I believe I'm gonna have to have a social worker go out and visit Mr. Roberts. So Thursday, that's okay. We can put it on for next week.
Okay, so we'll put it on for next Tuesday then.
Correct, Judge.
Okay. Where to next?
Position 31, 32, and 33, Mr. Sheets.
Okay.
His attorney is on the line, Judge.
Kenneth Muhammad for Mr. Sheets, Judge.
Good morning, Mr. Muhammad. What are we gonna do with Mr. Sheets today?
Do you hear me?
No, I did not. I didn't hear you.
Okay, I apologize. Yeah, Judge, we're just trying to deal with the issue of there was a bench warrant issued for failure to appear. They put it on today's calendar because he's been in custody, and there just happened to be a bond forfeiture hearing today as well related to that issue. For the court's knowledge, I've represented him at the time. He had a civil matter involving his wife, and these charges also involve his wife. They resolved the civil matter. They've moved on with their life. They've had a child since all of this happened. And somehow, some way between the different cases, it was some kind of mix up because I thought I appeared with him previously and I thought that there was an entry of appearance, but apparently there is not. I didn't get notice. He is, communicated with me. He's been on top of this. I know that the couple is beyond this and wanted to get it resolved, but there was a court date. We both missed the court date. I'd ask the court, because we're anxious to get it resolved, if I don't know if at this point with the bond forfeiture being scheduled for today, if it's possible to recall the bench warrant or if a new bond would need to be issued. But if the court could issue a new bond, we're asking that that be done.
Okay, well, why don't we let him just go to the bond forfeiture hearing? And whose court did he miss? What division judge?
Judge Edie.
Judge Edie? Okay, what I normally do in these situations is that I send him back to Judge Edie since he missed court with Judge Edie. You'll have to go back to Judge Edie if you want the bond, anything else done with the bond, okay?
Judge, I show that the bond forfeiture judgment calendar hearing was scheduled for September the 12th. I don't show one for today.
Okay, did you hear that, Mr. Muhammad? We don't show.
Okay, that from what I saw, it's going on starting at 10 o'clock. But in any event, it sounds like you're saying that there's no way to resolve the issue today, and we're really just trying to save him some time. Do you not have the ability to address that issue?
I have the ability, but my practice is that if another judge has issued a bond in the matter, that they go back to the division judge that issued that bond if they want it modified. So Judge Edie issued that bond. So if you want relief, you'll have to go back to Judge Edie's court, okay?
Okay.
Thank you, Your Honor.
Thank you.
All right. Good luck to you, Mr. Sheets. Have a good day, Mr. Muhammad.
Thank you, you too.
Who do we have next? You still with me, courtroom 2? All right, so I have that we still have positions 11, 30 on the regular calendar and Robert Stewart on the add-on calendar.
And Judge, the announcement from Mr. Stewart, I'm not sure if there were multiple calendars or add-ons, but there's 3 cases, and Mr. Stewart is a reset to the competency calendar. I've already submitted his referral and MHE order to Ms. Champion and Ms. Grace.
Okay.
What's the date for the reset?
Do you know the date, Ms. Helen?
I believe it's going to be November 8th competency calendar.
Okay. All right, so that being said, I still have positions 11 and 30 that need to be addressed this morning.
Your Honor, sorry to chime in late, but but there is no conference calendar on the 8th. We only do them on Thursdays.
Or whenever the next November Thursday calendar is.
So I think that would be the 10th.
Yes, so we'll do the 10th, Judge. And I have 3 competency calendar resets, so can the date for all of those be November the 10th?
Ms. Lewis, are you with me?
Yes, sir, I am.
Can you find out what's going on with courtroom 2 for me? Because they're not responding.
All right.
All right, thank you.
Needed us in courtroom 2, Your Honor?
I just want to make sure we have 2 that we still need to do, number 11 and number 30. So are we done in courtroom 2? Is this all going to be medical?
Yes, it should be the Rover, which is Officer Blunt. She's going to go to different floors. She should have position number 11.
Okay, and what about position 30?
And position 30.
Well, right now I have before you is the add-on, Mr. Robert Stewart, add-on 3.
Okay, we don't need Mr. Stewart this morning. He's going to be reset for the competency calendar on November 10th.
Oh, wow. Okay, I have to go to 3 North Grad. Okay, you said position number 11 and position number 30?
Yeah, that's you, Blunt, both of those positions.
Okay then, all right.
Okay.
Your Honor, the position number 30 is said to have a private attorney. Do we know if the attorney is on, whoever they may be?
And Judge, when I went and spoke to Mr. Scott, he said his attorney had spoken to him the day prior, Mr. Marks, I believe is his last name, and that he would be here today for him.
All right, so let's see. Can we get position 11, Daryl Davis, since we can deal with him? And
Okay, I have to go to 3 North to grab him, and I have to bring them one at a time because they on the combative floor, so I have to deal with them one at a time. I grab him, then I go get the other guy.
okay, so get Mr. Davis for me first. Thank you.
Okay.
And let's see. Has Mr. Marks entered a notice of appearance?
No, he has not.
Okay, does anybody have his phone number?
I spoke to Mr. Scott. He didn't have his number, but he said that he had spoke to him again just the day prior. Attorney Marks.
It's 10:40. No one's heard from Mr. Marks. I'm not sure what he wants to do with him, but the state is asking for additional jail time in this case. So why don't we just reset Mr. Position number 30 until next Tuesday to see if someone can get in touch with Mr. Marks. Anybody have an objection to that?
No, Judge.
No objection from the state.
Ms. Helen, can you please give me the full name of his attorney so I can look him up?
He only gave me Mr. Marks.
You don't know the first name?
I don't. So if Mr. Scott shows up today, maybe he has that information from his cell.
Okay.
Well, I'm not going to have them pull Mr. Sacro unless his attorney shows up.
Understood, Judge.
Okay. So we will be in. Why don't we do this? Can we go over the calendar? All right. Would you all like to go over the calendar while we wait?
Yes, Judge.
What add-on 1? What was the announcement? I'm sorry.
November 10th company. It's Robert Stewart.
My add-on 1 say Damian Bradbury.
That's correct. Bradbury's add-on 1.
Like I said, Judge, I believe that there was 2 calendars sent out and had
Oh, okay.
different names on them.
Oh, so I don't have a Bradbury on my calendar. What were we gonna do with Mr. Bradbury?
He was actually supposed to be represented by conflict counsel. I don't know if one had been assigned or requested, but he was reset to today for conflict counsel.
And I take it that we don't have a conflict attorney, Ms. Lewis.
That is correct.
All right, so we're gonna set him, well, since I don't have Mr. Bradbury, I don't know what the recommendation from the state is. Does anybody have that?
Oh, Your Honor, I have it. Give me a second. Sorry, I was working on no cross order forms. Let me pull that up.
I'm just trying to figure out if I should reset this for Thursday or. It can be
Yes,
reset for Tuesday.
So it's not gonna be a time served offer, Your Honor. It's a 12 month serve, 180 days, credit for time served, 17 days.
Okay, so why don't we reset Mr. Is it Bradbury for next Tuesday to see if we can get a conflict attorney? Okay.
Position number 1 is a plea. Position number 2 is reset SAP 10-6. Position number 3 is reset SAP 10-11. Position number 4 was a plea. Position number 5 was a non-negotiated plea. Position number 6 was a plea. Position number 7 was reset SAP 10-11. Position number 8 was arraigned and further notice. Position number 9 was a plea. Position number 10, defendant was released, reset further notice. Position number 11, we're holding on. Position number 12 was a plea. Position number 13, reset SAP 10-11. Position number 14, reset further notice, defendant released. Position number 15, reset SAP 10-11. Position number 16 is going to be reset further notice with a bond of $7,000 sign-on bond through the jail. Position number 17 is reset SAP 10-11. Position number 18 is reset SAP 10-11. Position number 19 was a plea. Position number 20, reset further notice, defendant release. Position 21 was a plea. 22 was reset further notice. Position 23 was a plea. Position 24, reset SAP 10-11. Position 25, reset SAP 10-6. Position 26 was a plea. Position 27, reset SAP 10-11. Position 28, reset SAP 10-11. Position 29, reset further notice, defendant release. Position 30, reset SAP 10-11. Position 31, reset further notice. Position 31, 32, and 33, reset further notice to divisional judge. Position 34 was reset further notice, defendant released. Position 35 was a plea. Position 36 was reset to the SAP 10-11. Position 37, reset SAP 10-11. Position 38, reset SAP competency 11-10. Position 39 was a plea. Position 40 was reset SAP 10-6. Position 41 was reset SAP competency 11-10. On the add-on, position number 1 was reset SAP 10-11. Position number 2 was going to be reset SAP 10-6. And position number 3, Mr. Stewart, is reset SAP 11-10. Competency. Any questions?
I believe it's position 29, just so let me, my apologies, I'm scrolling back up. For 29, the person was released, but it shouldn't be reset further notice. I did submit a null pros order for Judge Morrow to sign to April Champion.
When did you send it?
During court, so you may not have seen it yet.
Okay, I have it. Thank you.
No problem.
Okay, we'll be in recess until the jail comes back. And if you all will start getting your paperwork together to send him as champion, we'd appreciate it.
Position number 11 is present.
Okay, so we're planning this is going to be negotiated plea. You with me, Mr. McLean?
I don't understand what he's saying. You
Okay, hold on for me, Mr. Davis. I'll be right with you, okay? I'm trying to get your attorney on the line. Are you with me, Miss Helen?
Yes, Judge, I'll give him a call.
Thank you.
Can somebody get McLean, because this guy getting combated. I can't be fighting with him up here. Somebody need to get Mr. McLean.
I'm calling now.
Mr. McLean?
11 up.
This is position 11. It's going to be a plea. Is that right?
Yes.
Good morning, Mr. Davis. I'm Judge Eric Morrow. We're conducting this hearing by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me?
Is sworn in Blunt. Officer Blunt agrees. I agree.
Okay. Do you swear?
Mr. Blunt is my representative.
All right, Mr. Davis, can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Can you tell me today's date?
All right, Mr. McLean, I'm not certain that we can move forward with a plea on this matter today.
All I want to know, oh, there it is. Yes is the answer. I'm looking at the screen. I have good vision. Yes, Your Honor, I agree. I see the date. It's 10/4/22. I agree, Your Honor, I agree. Today, I agree.
Mr. McLean, we're gonna have to put this off. I'm gonna need for you to send a social worker down to see if,
Very good. We'll do that.
so I'll reset this for, I guess, next Tuesday to have a social worker. It doesn't appear to me that at the present time that he's competent to move forward with understanding, to be able to understand any plea agreement. So we'll reset Mr. Davis for
1 week.
All right. Thank you. We appreciate it.
What about position 30? Did his private attorney log on yet?
Yeah, we've reset that case until I believe next week also.
All right, sir. Thank you. Have a good day.
Thank you. We're done. You do the same. All right, anything further this morning?
Don't believe so, Judge.
Okay, thank you all. I appreciate it. We'll see you next week.
Thanks so much. See you next week.
All right, y'all be safe.
Thank you, Your Honor. Have a good day.